Hello everyone, my name is Rachita Mathur, currently working as a legal intern at LEXCLIQ. So today I'll be dealing with the topic writ of Mandamus. So writ of Mandamus can be issued against a public corporation and tribunal as it is directed to set the indolent authority to task. It is also described as a waking call depicting their activity and setting them in an action in pursuance of discharging the public duty. Further, while referring to the grounds of writ of Mandamus, we can say that Mandamus is a remedial in nature and can't be expressed as a writ of right, as it is issued only at a discretion of the court after the applicant of the same is able to prove to the court that some just question would be answered by the writ. So the essential ground necessary for the issuance of Mandamus has been enlisted below. First is there should exist a legally sanctioned right of the petitioner or the applicant or the writ, and a violation or compromise of this right has been committed. The infringement of the right of an application can be done by a public authority in the following manner. First is crossing the limit of the power and duty that is vested to their office. Second is failure or the omission to act responsibly according to the conditions which have been laid down by the law for the exercise of their power. Third is denial by an official or authority to perform their statutory duty. Fourth is a complete disregard for contravention of the principle of natural justice. Another ground for legality of issuing the writ of Mandamus is the failure to act or to perform the legal duty despite being demanded by the applicant for the same. Now, there was one case of Saraswati Industrial Syndicate versus Union of India. In this case, the writ should be applied for in a good faith without any ulterior motive or intent on the part of the applicant. Lastly, the writ of Mandamus can only be issued when no other recourse, redressal mechanism or legal alternative have been left at the disposal of the applicant. Further, we can say that the framework of law in relation to the Mandamus, the Supreme Court of India has been authorized with the power to issue writ under Article 32 of Constitution. Out of the 5 category of writ, there are a part of Indian legal framework the most appropriate for the enforcement of the right of the claimant shall be applied by the court, rightly described as the very soul of the Constitution and very heart of it by Dr. B.R. Ambedkar, right to constitutional remedy, or Article 32, which states that there must be a clear breach of fundamental right and not incorporate contentious factual question. Under Article 32, the writ can't be issued for the enforcement of governmental policy, and a statute violating a fundamental right can be contended against the Mandamus. Any executive or statutory order can be enforced by Mandamus following a due process of law. Over the course of year, it has been found that the continuous Mandamus or the writ of Mandamus issue against a prolonged failure to act on the part of the state agency, although the law is pretty clear with regard to the case or instances where the applicability of the writ of Mandamus stand. It has not been an easy decision for the Indian court and judiciary for applying this writ in the different cases, but this can become a significant question of law in the modern day legal system of India. Further, we will be looking at the type of Mandamus. So there are 3 types of Mandamus that exist within the Indian jurisprudence and has been developed over the years through a case law and judgment. So first is certiorarified Mandamus. So the basic difference between the two writs, certiorari and Mandamus, can be explained on the basis of jurisdiction. While the former provides for the judicial review of an already tried case by a subordinate court and checks whether a jurisdiction has been exercised, the latter takes into the account whether jurisdiction has been refused for getting exercised. Now, there was one case of Y. Mehboob Sharif and other versus Mysore State Transport Authority. In this case, the Supreme Court of India invalidated the previous judicial order of subordinate court in the effect of the writ of Mandamus that directed the concerned authority for the renewal of 3 years. Further, the second type of writ is anticipatory mandamus. There was one case of Magan Bhai Ishwari Bhai Patel versus Union of India. In this case, the court held that the mandamus shall not be granted merely on the suspicion of the violation of right unless some actual damage or infringement has been happened. Further, the another writ is continuing mandamus. So in this there was one example. There was one case of Kshetriya Pradyushan Mukti Samiti versus State of UP. In this case, it was being held that beside ensuring the adequate enforcement of the fundamental right, it also the court responsibility to ascertain the prevention of misuse of authoritative power and full adherence of the order. That's all for the day. Thank you.